Spectrum shirt, but that's about it. He went in and he killed her and stabbed her to death. The trial happened over the last couple of months, and the Dallas County jury found that Charter Cable, although he was not on the clock, he went over there on his own, was 90% responsible, and they came back with a $7.375 billion verdict. So for those that think, I've got insurance, I don't care, let the insurance companies worry about it. Right now, Charter Cable's having some very expensive and awkward meetings, conversations with appellate lawyers, with bonding companies. They reported that they have $300 million in coverage, so they have a $7.375 billion verdict. So this stuff is important, and right now I think Charter's being reactive instead of being proactive. And I don't know enough about the facts of that case and how it went down on prepping witnesses, so it wouldn't be fair for me to be too critical of them, but that's just an example of. What's that?
It was followed in Dallas County.
Yeah, well, that's another thing. Dallas County is an awful place to, on the defense side to be right now. That the juries are going nuclear on all these verdicts. So Tyler and I are going to talk a little bit about dram shop, litigation, premise liability or slip and falls, use of force, police investigations, fraud or unauthorized credit card use, and deposition. First, I'm going to talk a little bit about dram shop. For those that don't know what dram shop is, it's when a patron comes into an establishment, is allegedly overserved, and then goes out on the road and hurts himself or somebody else. There's first-party dram shop cases, which are when I call them the drunk, when the drunk goes out and they hurt themselves. They run into a tree, and then they decide, hey, I'm going to sue the bar. Some states don't even allow that. Unfortunately, Texas is one that allows that. The third-party dram shop cases are a little bit more concerning. Those cases have to do with an intoxicated patron leaves a bar or restaurant, goes on the road, and somebody that's minding their business, driving down the road, gets T-boned by this drunk driver, and then they or their family sues the bar for overservice. This is an example of what can happen. This was a dram shop case we had with a patron that left a restaurant. This is a UPS in-camera video of a UPS driver just driving illegally down the roadway near Austin, Texas. Fortunately, in that case, we were the first of 3 establishments that this gentleman went to, and we got out for a very low number, less than $5,000. I don't know what happened to the other 2 establishments, but I would hate to be the last establishment that that guy went to that night, because that would be hard to explain to the jury why he was on the other side of the road. So obviously, Tyler and I, out of Texas, we've got offices in Texas and New Mexico. We try cases wherever we're called. This presentation will be mainly keyed on Texas law, but there's other dram shop laws out there. I'm sure that most of you may or may not be aware of this, but obvious intoxication is what Texas and Arizona is. And that basically means at the time of service, was it apparent to the provider that the person was obviously intoxicated to the extent he presented a clear danger to himself and others? That's a Dram Shop Act, and it's actually designed to protect the provider of alcohol. Plaintiffs' attorneys try to make it into strict liability. We'll get into that in a little bit, but that law is actually it's a pretty tall burden. I mean, at the time of service, the person must be obviously intoxicated. I've questioned experts on the plaintiff's side, on the side of the families that are suing establishments, and had them all confirm that if somebody takes 50 shots and isn't served anything else and goes out and kills somebody, They didn't violate, that establishment did not violate the Dram Shop Act. Now, they may have to answer to the TABC on over-service, on the administrative level, but that wouldn't be a violation of the Texas Dram Shop Act or the Arizona Dram Shop Act. I'm not recommending that you do that, however. New York does visible intoxication. I wish that Texas and Arizona had the word visible as opposed to obvious intoxication, because plaintiff's attorneys try to say obvious intoxication can mean if you knew the person was above a .08 or legally intoxicated, and the person's obviously intoxicated, you shouldn't serve them anymore. I think that the statute, Texas and Arizona, should have the word visible. It doesn't. New York does. Florida is, if I was a dram shop lawyer in Florida, I would be out of work, because apparently you have to know that the patron is a habitual alcoholic at the time of service to be held liable under the Florida Dram Shop Act. So that one really protects the establishment. They've got strict liability for Alabama and Illinois. Strict liability is basically what plaintiff's attorneys are trying to do with obvious intoxication, which we'll talk about in the next slide. And then you have anti-dram shop liability in California, Delaware, Virginia, and Wisconsin. What that means is it's just a negligence standard. What jury's going to be asked, what would a bar or restaurant in the same or similar circumstance have done in this situation, and was it negligent? So those are the various by states, as a sample of various ones by states. So obvious intoxication, what does it mean? Plaintiff's attorneys try to twist this and say, well, you know, I can't express how important it is to have your employees prepped before a deposition, right? They go to a deposition, they walk in there, and they may be 18 years old and scared to death. They got a camera in their face. There's somebody taking down everything that they say. Court reporters typing out everything they say. There's 2, 3, 4, 5 lawyers in there that are yelling at the server, yelling at other lawyers. It's very distracting, it's nerve-wracking, it's not a normal process. And if you have a server that goes and sits down and depositions being taken over, and a plaintiff's attorney throws this chart, says, you've seen this chart before in your training, haven't you? Your TABC training, which is Texas Alcohol Beverage Commission training, and every state's got, most states have similar organizations where they show this chart. Plaintiff's attorneys have no idea where the chart came from. I can tell you it came from NHTSA, and no one's ever been able to tell me whether or not this is a scientific chart. And I can tell you it's not, because everybody's different. But TABC, for example, uses this chart during training. It says, you know, you should be able to tell, look at somebody, identify how much you think they weigh, and then if you serve more than 3 drinks and they weigh 150 pounds, well, let's look over here. It says 0.08. So 0.08, well, man, would you agree with me? It says legally intoxicated, right? Did I read that correctly? Yes. Well, would you agree with me? Then the person's obviously intoxicated. It says so right here. Yes. And then it's like, oh gosh, the plaintiff's attorney thinks he has an admission, we just admitted liability. Well, that's not the standard. It's our job to prep these witnesses beforehand and say, look, this is just a tool, but it never replaces observations at the time of service. Because how do you know whether or not the person drank before they got there? What if the person had 10 drinks beforehand, and the server goes, well, I know the guy weighs 240 pounds, so I know that I can at least serve him 4 drinks. Well, that would be bad, right? And so this chart never replaces observations at the time of service. I told you earlier about the Dram Shop Act, or the question that the jury would be asked, which is, at the time of service, was it apparent to the provider that the person was obviously intoxicated to the extent they were a clear danger to themselves and others? That last part talks about the level of intoxication. Must be a clear danger to themselves and others. Well, that part of the statute mirrors public intoxication statute in Texas. And so plaintiff's attorneys try to create strict liability by using this chart. I try to then bring it back and go, if a police officer was there at that time, do you think that that individual would have been arrested? Would that person have been arrested for public intoxication? That's the level of intoxication that we believe and that we argue to a jury that must be proved by a plaintiff in order for them to be successful in proving a dram shop case. I won't get into this. You can't read it, but there's 50 signs of intoxication. This comes from Garrett's Intoxication Handbook. It's a book about that big. Toxicologists across the world call it the Bible. And these are the various signs. I mean, there's some that are real obvious, like vomiting or urinating on yourself, and there's others that are not, where it's slurred speech, blurry, watery eyes. So the reason I put this up is a plaintiff's attorney will always try to find something for these 50, and there's a lot on here, and get a server to admit, well, would you agree with me? Right there in that video, I saw a little bit of a sway, didn't you? And so it's important, and these videos are great. I've said 99% of the time, I think videos vindicate us. But there are parts of the video that I have to tell the jury, the server wasn't there when this happened. And because the key is the server observed, the staff observe it, not if, the video in the corner sees some guy go like this. That's not the standard. Obviously, these are things that should be taught to servers, and it goes towards their TABC or their various state alcohol commission training. I highly recommend pre-shift meetings. Highly recommend alcohol policies that are actually signed by the employees. The alcohol policy is important for the safe harbor defense. Some may have heard of that. There's 3 ways for us to win these cases in Texas. One is plaintiff can't prove that the person was obviously intoxicated at the time of service. Even if they say yes he was, we still get a question 2, is safe harbor defense. And that means basically there's 3 prongs to the safe harbor defense. One is, did the establishment have a policy that everybody be TABC certified? 2, was the employee serving TABC certified? Those are our burdens of proof. And then the 3rd prong is plaintiff's burden, which is, did the establishment encourage either directly or indirectly over service of alcohol? And that's where they go into, the Texas Supreme Court says any type of drink quotas would be an example of encouragement of over service. Unfortunately, they don't have an exclusive or an exhaustive list of what does apply as encouragement, so plaintiff's attorneys will point to such things as bottle service. We argue that's not encouragement. But these are various things, obviously, that staff should look at: how long a person is drinking, how many drinks a person consumed within a period of time, whether the person was alone or with a group, whether the person consumed food or water, or was just consuming alcohol the entire time, and then the age, weight, and height of the individual involved. That goes more towards that TBC chart. This goes towards what I just talked about, the safe harbor. Best practices is to mandate that all employees undergo the seller server training, and that they maintain valid certificates. I can't tell you how many times I have a server who says, yes, I had a certificate, I got it 5 years ago, I know it's only valid for 2 years, but I just got busy and never got around to it. Or a manager that says, it's my fault, I'm supposed to make sure that everybody's TABC certified, but this person, they expired last month, and I forgot to tell her to go get, he or she to go get recertified. I argue, and try to keep a straight face, that the safe harbor provision does not say an unexpired certificate. It says attended a commission-approved course, but that's what I have to do when I'm not provided with valid TABC unexpired certificates. So I don't know I have clients that have point-of-sale systems, login systems that don't allow employees to log in if they have an expired certificate. I highly recommend that. That is a safeguard to make sure everybody's TABC certified. If someone displays signs of intoxication, make sure the staff is trained on how to act. Notify the manager, notify the other employees. We've seen where people get cut off and they go to another bartender or another bar on another floor at the bar or the restaurant. Notify third-party security. Monitor the individual, provide them food and water. Discontinue the service of alcohol to that individual. Secure a safe ride home for that individual, whether it's Uber, Lyft, cabs. We've got examples here a little bit of of clients that have done all this, and we had favorable results. And also, take the keys away from the individuals. And if you have to, call the police. I can tell you that if you've ever had a dram shop case and you're the corporate representative or the owner or the president or the CEO, and you have to sit at a mediation across parents whose daughter was just doing nothing but driving down the road and they're crying because they don't have a daughter anymore, that's not fun for anybody involved. And so I highly recommend that teacher staff be proactive on all of these things, and call the police if you have to. So we've just got a couple of examples, and then I'll turn it over to Tyler of dram shop examples. This case is called the Ariano case. It was in Dallas, Texas. We tried this case a month before COVID really hit. This was 2019, December of 2019. Which is not a good time to try a personal injury case as a defense attorney, because it's Christmas time, and juries tend to want to be giddy. So we had a patron that went into a restaurant to watch the Maverick game. He was there for 4 hours plus, drank 6 beers, 1 to 4 shots. Towards the end of the night, he was asked to leave. Patron left the restaurant in a cab. We have video of us putting him in the cab, which is great. Unfortunately, he asked on the way home for the cab driver to pull over at this gas station. He paid, he left, and an hour later, as he's walking home, he gets run over by a car and dies. The family of this individual sued the restaurant under the Texas Dram Shop Act. And here is a video of the individual. I don't know if everybody can see this, but this individual with the hat on right here is Mr. Ariano. And the reason why I'm playing this is not to show you how fantastic he looked despite all this alcohol. It's, you have to understand that plaintiffs are going to key in on any little thing they can find. And this is an example that we saw this flip over and over again. But this is not when he's getting served alcohol, and they couldn't really prove that he was served after these signs of intoxication. There's no audio on this. This is Mr. Ariano. So you be the judge. If you're asked to be a juror on a dram shop case about overservice of alcohol, and you heard about how many drinks he had, you watched this video. Some would say he's just having a good time. Some would say maybe a little intoxicated. Well, saw that many times at that 3-week trial. Here's another video of Mr. Ariano. He's going to walk up here. Here he is right here. Looking up at the TV. So if you're not used to being in an environment of a bar, club, or restaurant, and you're a juror, you may say, that's obvious intoxication. When I said he got rowdy and was asked to leave, here's a clip of that. There's Mr. Ariano, right here. Slams his fist down, but within 10 seconds, third-party security asked him to leave. They acted promptly and appropriately, removed this person, and make sure he had a safe ride home. There's third-party security right there. Sir, it's time to go. There's the manager. And he leaves and goes, and we've got a video of him getting in a cab. After a 3-week trial in Dallas, we obtained a complete defense verdict on that. And the reason why we did is because of all the proactive actions and training and what to do when they had a situation like that, and acting within 10 seconds to remove the person and not kick him to the curb, make sure he has a safe ride home. And the jury saw that and found in our favor on December the 20th of 2019, which is, again, juries usually like to give out money for Christmas, so that was and they were deliberating for a week, which is not a good thing for a defense lawyer, because you think they're like working on a calculator and figuring out how many zeros and carrying the two at that point. Here's a second example of a dram shop trial that we had. This one is the Sullivan case near a club near Austin. One night, the patron, it was determined that the patron should not drive home. He drove his pickup truck to the club that night. He had bottle service. The club took appropriate action and tried to prevent him from leaving. The club offered him a cab ride home. The patron refused the ride because he did not want to leave his brand new truck in the parking lot. The club offered to drive the patron's truck to a hotel and pay for a hotel room, but he refused the offer because he did not have identification to complete the reservation. The manager then offered to rent the hotel room in his name, but the patron again refused the offer because he didn't want anyone to drive his pickup truck across the parking lot. And this club had a hotel, a couple hotels just across the parking lot. The club initially refused to return the patron's keys to him. He had used valet, but allowed the patron to have his keys so that he could charge his phone. He said his phone was dead. This is after the club had allowed him to stay 2 hours and sober up. He asked for his keys, said, "I'm just going to charge my phone." He was warned, okay, but if you start that car, we are going to call the police. And he started the car, and the police were called. Here's a video of the in-car dash camera of the Round Rock Police Department. Mr. Sullivan is in the white pickup truck right here. He had already started his car. The club called police immediately, and they arrived within 2 minutes of him starting the car. When he hit the ground, he broke his back and severed his spinal cord and was rendered a quadriplegic. The plaintiff at the time, I think, originally sued the Round Rock Police Department in federal court in Austin. After being in the hospital for 3 or 4 months, accumulating $2.6 million in medical charges, he died. So his mother then took over the lawsuit and decided to add in the club into the lawsuit for dram shop. The Round Rock Police Department were dismissed. Next slide. Round Rock Police Department was dismissed in a federal court case for qualified immunity. So that just left the club. And this was a regular that frequented this club, and he never would have sued a club, especially a club that was bending over backwards to make sure he got home safely that night. The mother sued for Texas Dram Shop claim and also negligent undertaking, which means once you take the keys, there's an argument that you have now incurred a duty to make sure the person gets home safely. Once you say, "I'm going to get you home safely." Those are the two claims. Clearly that was not the case with these facts. After a 2-week trial in Austin, we obtained a complete defense verdict for the club. And that was because of all those proactive steps. I've never seen so many steps to make sure somebody gets home safely after they've had too much to drink. But that being proactive makes our job a lot easier. I think this is my last example. It's a third example of a Texas Dram Shop case. Patron was at a restaurant in Houston with a large group. He was there for 3.5 hours. He was served 10 shots while he was there. Patron left with a group of friends, did not drive. And he went to a friend's house. You know, there's law out there in various states that say once you get home to a safe repose or to a safe place, the bar's off the hook. But there's other states that say, nope, you're on the hook until he wakes up the next morning. I mean, it's pretty ridiculous. You gotta tuck, I say, what do we have to tuck the guy in bed? And sometimes the guy goes to sleep. There's been cases in Arizona. Guy goes to sleep, wakes up, girlfriend says, hey, can you take my girlfriend home? Wakes up, goes, gets in an accident, and then the bar is responsible. So, you know, those are, I think, legal issues that the appellate courts will resolve eventually, but it doesn't prevent lawsuits where you have to go and try your case in front of the judge and the jury. This individual went to a friend's house, and there was a ZX-10 motorcycle that the patron asked to see. While the friend's back was turned, the patron jumped on the motorcycle, took off down the street. During the ride, the patron hit a parked car and suffered multiple injuries. And the patron sued the restaurant, asserting dram shop claims. And got some video of this individual, I'll point him out. He's wearing red. He's right here. This is him at the restaurant. He's holding his hands up. He's actually got some pretty good moves. He's dancing. He's having a good time. There he is again, gentleman in the red right here. Here are the good facts for the defense in this case. The servers were clear that every time the patron was served alcohol, they evaluated him for signs of intoxication. We had video to back that up. While leaving, the patron interacted with an off-duty police officer who were hired as restaurant security. There's the patron right there in the red. There's the off-duty police officer, another off-duty police officer. They're interacting. This is as he's leaving. Guy in the red, the police officer, comes back. I thought this was going to end horribly, but he comes back and shakes the hand of the police officer right there. That helps out, especially when I say the standard of intoxication is that of public intoxication. That guy, if he was to that level of intoxication, that officer would have acted. He didn't think so. So that helps us out immensely when you have third-party security, and if you can get off-duty police, that's even better. And that really helped us on this case. Patron's friend who owned the bike testified during his deposition that the patron did not show signs of intoxication during their interaction. If the friend had seen signs, he would not have shown him the motorcycle. That was the testimony. The friend was furious when he found out later that the patron had so much to drink. The results of this lawsuit, court granted summary judgment in the restaurant's favor and dismissed the lawsuit in its entirety. Summary judgment is, for those that don't know, we move for them, I think, in probably every case. They're very difficult to win. It basically is the judge saying there is not enough evidence for this case to go before a jury. They're extremely difficult to get, especially in Texas, because there's no right to appeal. So there are some judges out there that deny them without even reading them. So we were successful in this one because of all those great proactive facts that we had. And now I will turn over to Tyler Stewart.